The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody. My name's Joanne and I'm Head of Marketing at AFTA. With me today, I have Courtney Duddleston, who is Head of Strategy and Finance. Courtney has been running several rent relief package webinars, and today she's going to give you a further update as the various state and territory governments begin to legislate rent relief in their jurisdiction. Before I hand over to Courtney, this webinar is being recorded and it will be on the AFTA website by 5 o'clock today. So if you just follow the quick link on the homepage, as I've highlighted with a visual representation there, it'll take you through to the webinar recordings. You're in listen-only mode. However, please use the question toolbox to ask any questions that you might have. If we don't address your question today, it may be that we think it's more appropriate to take it offline, so we'll loop back to you separately and directly via email. If you've got any questions that you think of after the webinar, please feel free to email afta@afta.com.au. I'll hand you over to Courtney now.
Well, thank you, Jo, and good afternoon, everyone. It's great to be able to present this webinar again. For those that have not seen this before, welcome. I hope that today's presentation will help to unpack this package for you. For those who have already heard this, then welcome back. And I do hope that the rerun today will give you an opportunity to further understand this and hopefully answer some of your questions that might have popped up recently. So on the agenda today, I will help to set the scene first and provide some background information on the announcement that was made previously. We'll then dive a little bit deeper into the new Code of Conduct and the key principles within the code. And now, as someone here may be aware, just recently, New South Wales passed regulation around the code, the retail and other commercial leases COVID-19 regulation of 2020. So we will go through this in quite some depth, how all of this applies, and I'll also provide an update on where the other states and territories are at with their own regulations. And then to try and put it all into context for you, I've included some examples of how it would work practically in your business. And we should have some time at the end for any questions that you might have. Okay, so we know that businesses are still having to pay their landlords, even if their workplace has shut down or their revenue has reduced to zero, which in the travel industry is certainly the case. We're seeing businesses face the perfect storm. It's a drop-off in revenue coupled with continuing fixed costs, one of them obviously being rental obligations. And so while commercial tenancies are regulated at the state level, by releasing this new Code of Conduct, the government has essentially set a standard for sensible and pragmatic solutions for landlords and tenants to work together. So in April, the National Cabinet announced a mandatory Code of Conduct, or the Commercial Tenancies Code. Essentially, the code is intended to mandate a set of good faith principles to be applied to commercial, retail, and industrial leases. Eligibility for the code is based on a business's eligibility for the JobKeeper payment. That being, they're a small to medium enterprise with an annual turnover of up to $50 million, and they have experienced a downturn in their business. The objective of the code is for a landlord and tenant to share in a proportionate, measured manner the financial risk and cash flow impact during the COVID-19 crisis. It's about seeking to balance the interests of both the landlord and the tenant. It's expected that a landlord and each eligible tenant will negotiate a tailored, bespoke and appropriate temporary arrangement on a case-by-case basis. And it's important to highlight that while this code has been announced, if you have already looked at what you can afford and you've been able to identify a solution with your landlord that you're both satisfied with, then that is completely fine. The introduction of this code is about ensuring both a landlord and a tenant essentially come to the party and work together to ensure that both carry some of the burden. So what are the actual provisions under the mandatory code of conduct? Well, let's run through some of the key principles. There will be a proportionality to rent reduction based on the decline in turnover to ensure that the burden is shared between landlords and tenants. And I will go into this further with some examples to try and put this principle into context for you. Landlords will not be able to terminate leases for non-payment of rent. Tenants must continue to comply with their lease obligations, otherwise tenants will jeopardise the protections that are provided by the code. There will be a ban on landlords passing land tax to tenants and a ban on landlords charging interest on unpaid rent. There will be a prohibition on penalties for tenants who stop trading or reduce their opening hours. There will be a prohibition on landlords making a claim to a bank guarantee or a security deposit for non-payment of rent. Landlords should allow tenants to extend the lease for a period subject to the rent deferral. And lastly, there will be a freeze on all rent increases. Okay, so let's try and break this down. Here is what we know so far. So will your landlord reduce your rent bill? Well, the mandatory code of conduct that was signed off by National Cabinet includes a provision that will force commercial landlords to accept rent reductions in proportion to a tenant's decline in turnover due to the COVID-19 pandemic. This will be achieved through a combination of rent waivers and deferrals. Tenants are being encouraged to share turnover information with their landlord to enable negotiations about how big their rent reductions should be. Although the government has been clear, this measure does not remove a tenant's obligation to honour the terms of their lease. Landlords are required to offer tenants at least 50% of their rent relief as waivers over the course of the pandemic period, and the remainder in deferrals. Deferrals are required to be covered over the balance of a tenant's individual lease term. So meaning, for example, tenants that have 3 years left on their lease will be able to gradually pay deferred rent over the course of their 3-year agreement. Those with less time on their leases, so for example, 6 months, they would have 2 years after the pandemic period is over to pay that deferred rent. And so the bottom line is, landlords cannot refuse requests for rent relief to SME tenants, that's small to medium enterprise tenants, that are eligible for the JobKeeper scheme. Waivers and deferrals will be negotiated individually, but they must follow the terms of the mandatory code. So how do you know if your business is eligible to negotiate under the new code? Well, only small and medium businesses with $50 million in annual turnover or less, which are eligible for the JobKeeper wage subsidy scheme, can negotiate under the protections in this new code. And we know that the eligibility criteria for the JobKeeper scheme involves showing your turnover has declined at least 30% on a comparable period a year ago of at least a month, which encompasses all travel agencies in Australia. So the bottom line is, only businesses eligible for JobKeeper payments can negotiate under this new code. And so even after the COVID-19 pandemic, can a landlord still evict a tenant? Well, National Cabinet agreed to a nationwide moratorium on evictions in late March, which means small and medium business tenants cannot be evicted from their premises for a period of 6 months. The mandatory code introduced last month also includes a provision that will prohibit landlords from terminating leases or padlocking stores for the non-payment of rent. when we know that the Morrison government has been very clear that it expects tenants to honour the terms of their lease and pay their rent where possible. But the intention of the code is to prevent landlords from evicting tenants for non-payment of rent during the pandemic period after the moratorium expires in 6 months. And so the bottom line is that your landlord cannot evict you for non-payment of rent during the pandemic period and must comply with the eviction moratorium, which is slated to last 6 months. So tenants are also protected from any rent increases during the pandemic, with the mandatory code including a specific provision that freezes rent increases. Commercial landlords are prohibited from charging penalties to tenants who stop trading or reduce their opening hours over the course of the pandemic, and they are also banned from passing on land tax to tenants and from charging interest on any unpaid rent. After the pandemic period ends, and there is no concrete date for when that will be, landlords are free to resume rent increases along the terms outlined in the individual lease agreements. And so the bottom line is rent increases have been frozen throughout the pandemic period and all additional penalties are waived too. And so who exactly is enforcing this and what happens if your landlord does not cooperate? Well, state and territory governments are ultimately responsible for commercial tenancy arrangements, which is why each jurisdiction must pass their own law giving effect to the mandatory code of conduct. So enforcement will be left up to the states and it will be overseen through a binding mediation process. Ultimately, though, it's about both parties coming to the party together and negotiating. Binding mediation will enforce breaches of the code, but it will look different depending on where your business is based. And that does bring me to my next slide now. So just recently, we know that New South Wales passed the Retail and Other Commercial Leases COVID-19 regulation of 2020. So as I mentioned earlier, it's the state and territory governments that are responsible for commercial tenancy arrangements. So I will go through the New South Wales regulation and provide an update on where the other states and territories are also at with their own regulations. So this new regulation in New South Wales amends 2 current regs. It's the Retail Leases Act of 1994 and the Conveyancing Act of 1919. To incorporate and reflect the principles of the code with respect to commercial leases. So the purpose of the regulation essentially is to give effect to the code and particularly to prohibit and regulate certain enforcement rights of landlords during the COVID-19 pandemic period and to reduce landlords and tenants to renegotiate the rent require them to renegotiate the rent and other terms of retail and commercial leases in good faith, having regard to the code before any enforcement action can be commenced. Okay, so the regulation takes effect on 24th of April 2020 and is repealed automatically on the 24th of October. So that being 6 months after it commenced, or as they call the prescribed period. The regulation defines a commercial lease as a retail shop lease under the Retail Leases Act or a commercial lease under the Conveyancing Act. The regulation applies to tenants if they qualify for the JobKeeper scheme and the turnover of the tenant was less than $50 million in the 2019 financial year. And now if you're a franchisee on here, it is the turnover of the business conducted at the actual leased premises. And if the tenant is a corporate group, then it's the turnover of the group itself. The regulation also prohibits and regulates the exercise of certain rights of landlords relating to the enforcement of leases during the COVID-19 pandemic period. And lastly, it requires landlords and tenants to renegotiate the rent and other terms of their lease in good faith, following the principles of the code before any legal action can be commenced to enforce certain terms of the lease. Now, there is an exclusion that I'll just highlight, which are leases that are entered into after the date of the regulation. So any new lease that is entered into after the 24th of April is excluded. However, this exclusion does not apply to existing leases that are renewed or extended after this date. So what are the prohibitions and restrictions that apply to the New South Wales regulation? Let's run through a list of restrictions that apply to the landlord of an impacted tenant. A landlord must not take any prescribed action against an impacted tenant due to the failure to pay rent, the failure to pay outgoings, or not being open during the trading hours in the lease. In the next slide, I will go into more detail on what those prescribed actions are. A landlord must not increase the rent during the prescribed period. And remember, the prescribed period is the 24th of April till the 24th of October, so that being a period of 6 months. A landlord must not take action after the prescribed period for any failure to pay a rent increase, which would have otherwise applied during the prescribed period. If an impacted tenant pays an amount for land tax, statutory charges or insurance, let's say, then a landlord must pass on the appropriate proportion of any reduction that they receive to the tenant. Anything an impacted tenant is required to do or not to do under either Commonwealth or state COVID-19 pandemic laws, so that may be to be completely closed up, for example, does not constitute a breach of a lease and does not allow prescribed action to be taken by a landlord. And lastly, none of the above here on this list prevents a landlord and an impacted tenant agreeing to a prescribed action being taken. Okay, this is the very busy slide. So the New South Wales regulation, as I mentioned, has come out, and as part of that, what's called a prescribed action. So that is, a landlord of an impacted tenant must not take action under a lease, seek orders, or commence proceedings of any of the prescribed actions. So let's go through the list of these. This includes the eviction of an impacted tenant, recovery or actions of possession of the premises, the seizing or the forfeiture of goods of an impacted tenant, making a claim for damages against an impacted tenant, the charging of interest or any other fees for any unpaid rent, the recovery of a tenant's bank guarantee or their security bond that has been provided under a lease, or a claim under any other guarantee. The landlord cannot terminate the lease of an impacted tenant. And lastly, they cannot commence proceedings of any other remedy that is otherwise available to a landlord. So what comes next? So if you're a tenant based in New South Wales, then our suggestion would be to familiarise yourself with the principles of the code. And we did go through these earlier, and they will be included on the slide deck when we send around a recording of this webinar later today. We would also suggest that you seek legal and accounting advice specific to your circumstances and work through your financials and identify an affordable solution that you can put forward to your landlord and begin instigating negotiation in good faith and in accordance with the code. And if you're from a different state or territory, then my suggestion is to start doing the same. Start prepping your financials now, get your legal and accounting advice on the application of the code, and speak to your advisors about what is an affordable solution for you. And remember, if your landlord is playing hardball or they're denying you a rent reduction, then they're not following the principles of the code. And that to me is not showing good faith negotiations, which means then they are therefore unable to take any prescribed actions that we went through earlier, such as an eviction. So if you're not from New South Wales, what is the latest for you in terms of your own state's regulation? Well, first off, for those businesses in Queensland, a national binding code of conduct has been developed for commercial tenancies. So Queensland is currently working to implement the principles of this code into regulation, which will help tenants negotiate changes to lease arrangements. And I've included a link to the Queensland business.gov website, which has some really helpful updates around this. For those businesses that are in Victoria, the COVID-19 Omnibus Emergency Measures Bill of 2020 was passed on the 23rd of April. The legislation applies to commercial tenancies regulations, and it was effective from 1st of May to give effect to the National Cabinet's mandatory code of conduct. The legislation will then sunset in 6 months after the commencement, so with the prescribed relevant period being the 29th of March until the 29th of September this year. We might have some WA members on here too. So the Western Australian Government recently proposed the Commercial Tenancies COVID-19 Response Bill of 2020 and the Commercial Tenancies COVID-19 Response Early Termination Bill of 2020. And the legislation aims to put into effect the National Cabinet's mandatory code of conduct. So this response prevents a landlord from taking a prohibited action in relation to a small commercial lease tenant during the emergency period on the grounds of failure to pay lease or remain open. A prohibited action includes eviction and termination. And the legislation also restricts rental increases during this emergency period. Okay, and if you're from South Australia, the COVID-19 Emergency Response Commercial Leases Regulations of 2020 applies to you. It contains provisions preventing a lessor from taking a prescribed action in relation to a commercial lease, so such as eviction or repossession, termination, or the charging of any interest on overdue rent. And for those Tassie members that are on here, on the 9th of April, the Tasmanian Premier issued a notice which provided for an immediate halt to terminations for unpaid rent and an immediate suspension of rental increases for commercial tenants. In line with the code, these restrictions apply to commercial tenants with turnover of less than $50 million who are eligible for the JobKeeper program. The Tasmanian Government has also announced that it will introduce legislation to give effect to the National Cabinet Mandatory Code of Conduct. So let's try and bring this to life now with a couple of examples reflecting the application of the principle of proportionality and how it would work practically in your business. It's important to note though that this scenario is just an example and the circumstance of each landlord, tenant and lease, they are different and they are subject to negotiation and agreement in good faith. So let's look at Mary first. Let's say Mary owns a retail travel agency and has a commercial lease with a suburban shopping centre. Last year, Mary transacted $2 million through her business, making a gross profit of $200,000. She's currently paying $45,000 per annum in rent. Mary has established that due to COVID-19, she will have to temporarily shut her doors and will experience a 100% loss in turnover in her business. So Mary is eligible to be provided with cash flow relief in proportion to her loss of turnover experienced. So that being a 100% loss in turnover would result in a guaranteed 100% cash flow relief. Under the code, Mary is eligible to receive half of that as rent-free or a rent waiver, that being half of her annual rent expense, so $22,500. And the second half is provided as a rent deferral, so the remaining $22,500. And this deferral of rent is to be recouped over at least 2 years in a manner that's negotiated by both parties. And both parties will also need to ensure that any repayment of the deferred rent does not compromise the ability of Mary to recover from the crisis. So we'll have a look at another example here. Let's say Justin owns a travel agency that has a commercial lease agreement for his office space in the Sydney CBD. Last year, his business transacted $38 million in sales, of which $8 million was his gross income or his turnover. He currently has 3 years remaining on his lease agreement and is paying $170,000 per annum in rent expense. Justin has established that due to COVID-19, his business will experience a 60% decline in revenue, guaranteeing him 60% cash flow relief to his business. So 60% of his rent expense is $102,000 per annum. Justin's cash flow relief would be provided as half as rent-free or a rent waiver, so that being $51,000, and the second half as a rent deferral, being the remaining $51,000. And again, the deferred rent of $51,000 is to be recouped over a period of at least 2 years in a way that's negotiated by both Justin and his landlord, but in a way that does not compromise his ability to recover from the COVID-19 crisis. So before we wrap up, this slide we included on Jason's weekly update last week. It really provides the steps that you should look to negotiate some sort of rent relief with your landlord. So once you've identified an affordable solution that you think you can make work, put this on the table with your landlord. My suggestion is be transparent, provide comparison figures to demonstrate the position that you're in, and let them know the other steps that you've taken to ensure your survival at the end of this. So this might include JobKeeper, having to stand down staff, the discussions that you've had with your bank to take out an overdraft or deferring loan repayments, also applying for state government grants that are currently available. So put on the table a solution and begin negotiations. And there are going to be landlords that they might play hardball, and some that just create a process to make the whole thing incredibly difficult. In those instances, refer back to the code. But the bottom line is, a landlord is not able to take actions such as the eviction of a COVID-19 impacted leasee for a particular prescribed period which has been identified in each of your state's regulation. So that's it from me. Jo, I might hand control back to you and see if we've got any questions from any members.
Thanks, Courtney. We have a few, not too many today. I've got a question from Keith, but it may have been asked before you got to the example. Keith said, so if our business has dropped by 100%, does that mean we can ask for 100% rent reduction?
So the way it works is a drop in 100% results in what they call cash flow relief, 100% cash flow relief. Half of that then is going to be as a rent waiver or rent-free period, and half of that will be as deferred rent. Okay, so you need to have those conversations with your landlord. But if you can demonstrate that you've got a 100% loss in turnover, you could confidently go to your landlord and request 50% rent-free and 50% as a rent deferral.
Thanks, Courtney. Viv's just asked a question to clarify deferrals. She said at the start of the webinar, you said that deferrals will be over the term of the lease, but then at the end of the webinar, you said it'll be over 2 years. When you referred to 2 years, Courtney, was that referring to if you had less than 12 months on your lease?
That's correct. So if you've got a period of, let's say, 3, 4, 5 years left on your lease, then you could negotiate with your landlord the deferral of your rent over the period of your lease. However, if you've got less than 2 years on your remaining on your lease, let's say 6 months or a year, you still have up to a period of 2 years, so 24 months, to pay back that deferred rent.
Thanks, Courtney. In terms of that, Viv has just asked, what about proof to demonstrate? And I guess she's asking, is there any rules on how the proof needs to be provided, and must it be audited by an accountant?
Well, no. My understanding is there's no need for an audit, and there is no set requirements to how it's provided. I'll talk in a little bit of context. Our landlord, AFTA's landlord, is Mirvac. They provided us with 5, 6, 7, 8, 9, 10-page documents, something like that we had to fill out. So we supplied them with our previous annual reports incorporating our financial statements, and we also provided them with some really high-level numbers about our projections pre-COVID-19 and our revised projections post-COVID-19. So I think it really comes down to what process your landlord's got in place, and they will all be different, whether it's a large listed company, you know, like Mirvac, for example, or it's a super fund of some sort, or it's a smaller company that that is your landlord, what sort of process they've got in place and what requirements they have to demonstrate your drop in turnover.
And just to clarify and answer some other questions, as Courtney mentioned throughout the webinar, there's a lot of trust that goes into this. This is about benefiting both sides, both parties, both the landlord and the tenants, and it needs to be done in good faith. So your landlord may ask for certain documents, and you need to be able to negotiate with them what documents and visibility you will give to your business. Of course, there may be some costs involved to get audited records or the necessary documentation, but of course, you need to come to an agreement with the landlord about what you give them. And this is about being trustworthy. So hopefully that addressed some of the comments we have. Courtney, Debbie's asked a question around outgoings. Is there any clarification on that as yet, if that's part of the rent reduction, or is the rent relief portion just on the rent itself?
From what I've read, it's just on the rent itself. However, if your landlord is charging you for particular outgoings that they've been able to have a reduction on themselves, they should be passing that along to you. So I would be having that conversation with your landlord about that. But from what I've read, this is about the rent itself.
Thanks, Courtney. John's asked a question around gross income. He said, if turnover is defined as gross income, should this include JobKeeper as turnover?
No, I would not. I wouldn't be including the JobKeeper amount at all. No.
And I also think from a bookkeeping perspective, you wouldn't allocate JobKeeper as an income. That it's been notified that, you wouldn't put that as an income, would you, Courtney, in your bookkeeping?
No, wouldn't, no. Yeah, and particularly when you're providing comparison figures too. I mean, obviously JobKeeper won't be in your comparison figures from last year. So I wouldn't be including that when you provide your financials to your landlord.
And Courtney, is AFTA offering any support in case one of our members needs a letter to be written to the landlord to support negotiations? That's a question from Gary.
Yeah, I actually had an email just sent to me prior to this webinar requesting that. Gary, it might have been from you that you sent it through. So we are happy to accommodate any sort of requests like that and put together something, provide it, I guess, as well from an industry perspective, and just to really highlight to your landlord the crisis that the travel industry is in. So more than happy to accommodate those sorts of requests.
Thanks, Courtney. We have one last question from John, and John, I'm just going to acknowledge your question and we will come back to you outside this webinar. John's question is just in regards to exceptions for businesses with $50 million turnover or more. So John, we'll come back to you on that after the webinar.
Yeah, just on that quickly, I don't know what state John is in, but I know particularly in New South Wales, there is a lot of room for interpretation in the regulation in New South Wales about who is an impacted tenant and how big or small that business is. So if you fall into the category of being over the 50 million turnover, I would still be referring back to the code if you're in New South Wales anyway. As I said, there's quite a lot of room for interpretation there. Happy to take that conversation offline and provide some really helpful supporting materials around that too.
Thanks, Courtney. We've obviously done a very comprehensive job today because that was every single question we were asked. So well done. And look, everybody, thank you for joining us once again on this rent relief webinar. It's the last one we had scheduled on this topic, but of course, if more details come out from the various states and territories, we will be sure to disseminate that to you. And if the need arises, have another webinar. In the interim, thank you for your time today. Email any questions to afta@afta.com.au. You will get a short survey that comes out with the acknowledgement of you attending today's webinar, and would really appreciate it if you took the time to fill that out. So thank you very much, everybody, and hope you'll join us later in the week for some of our other webinars. Bye for now.
Thanks very much. Good afternoon.